Tēnā koutou katoa. Thank you everyone for this, attending this next session of our final hearing. This is actually a reconvening of hearing 15A. So we have the hearing 15A panel with us. Commissioner Siani Walker, myself, Robert Scott, Councillor and Commissioner Felicity Floyd, and Councillor and Commissioner Hidlipuk Hau. So we have, we're going to have a brief introduction from the reporting officer, Ms. Burkhardt, who's going to introduce this theme and topic to us, and then we'll be turning to our submitters to present evidence. Now, I understand that the Papua Kahi Corporation, you wish to present some commercially sensitive information. Is that correct? That's correct. Yes. Okay. Well, basically under section 42(1)(b) of the Resource Management Act, we have that power, and in particular to avoid the disclosure of trade secret or unreasonable prejudice to the commercial position of the person who supplied or is the subject of that information. We can chat amongst ourselves, and we agree that we can give you that commercial sensitivity. What we propose to do, obviously everyone in the room will hear your evidence, but we have a recording going on, and we will pause the recording whilst that commercially sensitive information is delivered to us, and then please advise us when it is no longer commercially sensitive, and then we'll then recommence the recording. Thank you, sir. Okay, so Ms. Burkhardt, will hand it over to you.
Mr. Scott, tēnā here tēnā ata, tēnā koutou. Nāre mō tapoi tahi corporation there. Nā mō ngāti hihia puki, tēnā koutou. Whānau District Council mō tuku tika. Tuku pōna mahi for Teresa Burkhardt Hau, Muri Whenua, the reporting team for this last part of the proposed district plan hearing here at 17, the Tangata measures, rezoning, multi-purpose zone trees, overlay, and areas of interest mapping and my presentation. Just a brief overview of the section 42A, and hopefully this works. So just as an overview of the submissions we received on this particular section of the hearing, for rezoning of the multi-purpose zone, we received 13 submissions and one further submission. The rezoning of the treaty settlement land overlay, one original submission, and areas of interest mapping, 5 original submissions and 2 further submissions. And the submissions came from various Māori land corporations, Māori land Apu Whenua trusts, iwi authorities, iwi development entities, Māori development entities, and individual Māori land owners. The key matters for consideration for these submissions were the retention of the multi-purpose zone as it applies to the majority of a specific site, the amendment of the PDP mapping of specific sites which are zoned variously, rural production zone, natural open space zone, and mixed purpose zone, to have the multi-purpose zone apply. The amendment of the PDP mapping of specific sites which are zoned multi-purpose zone to apply a new multi-purpose rural settlement or new Māori development rural zone, and the amendment of the PDP mapping of a specific site to include the treaty settlement land overlay mapping in addition to the underlying rural production zone. And the amendment of the non-district plan layer of the PDP to include areas of interest of 14 iwi and hapu management plans which were not already identified in that layer. For the issues raised and evidence for submitters not appearing today, various submitters sought to rezone from other zones to Māori purpose zone. They sought to create a new Māori purpose rural settlement or Māori purpose development zone, and they sought treaty settlement land overlays and the mapping of area and country management plans, area of interest mapping. For the submitters appearing today, for Tapuaitahi Incorporation, they seek to amend the Māori purpose zone and to provide for the use and development of the land holdings owned by Tapuaitahi at Te Ti. An interim recommendation was made in 42A, subject to further information, to introduce a Tapuaitahi Papakainga development area and an amendment to rule MPZ R5 in the Māori purpose zone chapter, to provide for an exemption to the maximum number of residential units for Papakainga and enable 20 residential units within the Tapuaitahi Papakainga development area. For the second submitter appearing today, Waitomo Development Trust, they sought the rezoning of a specific lot from rural production zone to Māori purpose zone, and that specific lot is identified as general land in the Māori purpose zone, and the PDP is intended to apply to Māori freehold land and Māori customary land under Te Tere Whenua Māori Land. So in summary, the key recommendations are to retain the Māori purpose zone of specific sites as notified, to retain the zoning of specific sites which are not Māori freehold land or Māori customary land as defined, and an interim recommendation subject to further information from Tapuaitahi. And the rest is a repetition of the previous slide. Okay, that's my presentation. Thank you.
Thank you very much.
Just to declare a conflict for Pukepoto, the potential, not a financial interest, but that's my marae from Puto, and so just declaring that. So I'm not sure how that might affect actually this process, but I wanted to make that clear in terms of that site.
Thank you for clearing that. That's a compliment you know before we hire. Any other questions from the panel members to Ms. Burkhart's presentation?
Kia ora, Teresa. Nā mihi kia koutou o Ngāti Rihia. Tēnā koutou nau mai haere mai ki Wainui a tātou. I suppose I was really interested that there were so many whenua, groups of people who were wanting to create a Māori purpose zone, and and the lands have been changed to general title, but they're still owned by whānau. And I understand that the zoning for a Māori purpose zone is meant to be only for the Ture Whenua Act and all that stuff, but there was such a number of requests for this thing, and I was wondering, is there any other I'll ask this question. Is there likely to be new legislation that will allow, because I kind of wondered if people were wanting to have the Māori purpose zone for Papakainga development, for funding, or for extra protection, whether they want to convert back to Māori land and haven't done so far. So I know that's outside this scope, but there was a significant number from Te Hāpua to Whirinaki to Pukepoto, Tapuaitahi. Just a question really, because I know this is bound by the district plan. I actually tried to bring somebody from Te Pauahi to find out, is there something limiting Just a part-time oiwa. Kia ora, Miss Katie. He mana o te rarawa. E hara mai, tautoko ki tautaka.
To address the first part of your question, what other pathways are there for Māori landowners who we know for there's a number of historic reasons why Māori landowners who have ancestral connection to whenua, but the titles in general, and therefore the Māori Pūkī zone hasn't applied to them. So there are provisions actually within the proposed district plan for Whakaanga housing on rural production zone where the majority of owners are. So there's Whakaanga housing provision there, and there is also in the process a national environmental standard for Whakaanga housing, which it may provide other options for Māori landowners where the Māori Pūkī zone does not apply as historic region. Is there some way to answering the question?
Not really, but that's okay.
Perhaps I help that. Similarly, there are government policy directions underway as well at this time to specifically facilitate kind of development. We don't have the details of how it applies. My recollection was that the tenure may or may not be a factor. And so in terms of being facilitating and enabling, I also note that similarly, we have a range of things that we are doing, Whānau District Council doing, we are looking at actively being more facilitatory in this space and engaging, as you're aware, in terms of the changes, structural changes to Te Hono and how that is going to work. So in a very practical, hands-on sense, irrespective of what the provisions might say, like we're looking and there's a commitment to funding, getting hands in a flex level on that. Generally speaking, to my understanding of some of the guiding principles through the amendments review of the Resource Management Act is to be more enabling and facilitatory generally, but also specific for Māori at the same time. So there are things coming down the tube, I guess, of regulatory responses, but certainly, yes, what's in front of us is what we know and what we're certain of currently, and we can then make your decisions based on what's in front of you right now.
Okay, thank you. That's quite helpful clarification. Any other questions that you guys have? Okay, so Mr. Hohaia, you're going to lead the charge, or Mr. Sanson, are you going to be the Munro? Okay, so we'll pass it over to Tapuatahi's Corporation. Is this the moment where we're going to be talking about commercially sensitive things? Or do you want to do an introduction first?
Yeah, so we'll do an introduction first, then we'll hand it over to our planner, and then I'll finish with the lay evidence.
Okay, thank you. Sure.
Kia ora tātou. Tono. Me pēnei pia te tīmata o tō tātou nei kōrero I mua I a koutou te rānei. E hira, mō he anau ko tīmata te koutou I raro I ngā manaakitanga me ngā krakia I tēnei hui nei. Ngari kauke mātou konei. O reira ka tīmata mātou me wa mātou nei krakia te tuatahi. Hei ārahi wa tā wa mātou nei kōrero. Nā te mea I roto e nei kōrero e whenua tuku iho. E whenua mai konei, ngā uri e noho nei. O reira ka pēnā tāku tīmata. If you just bear with me, I realise that this hearing would have started with krakia this morning. We unfortunately weren't here at that time, so I'd like to conduct our krakia because of the importance of our kōrero that we're about to lay in front of you. And that kōrero relates, of course, to our lands, the tukuiho that have been in our hands for centuries. So it's fitting that we start that way. Nā reira. E io nui e io roa i o take i o wānanga. Nei mātou e ahuana ki tēnei taku ki tō aro tapu. Ke arahi ana koia mātou e whai ana i te aka tapu ki ngā hua. O i o nuku, o i o rangi, o i o no nehera. Kia uai ki te matapuna o te ora. Nā au anu i o e he aro matua, he aro tipua, he aro tawhito. Kia whai mātauranga he aro tapu kia koe i o e tukuna mai. Ko toke rau te tūtei ki te hauraro o te pūaha, ko rākau manga ki te rāwhiti. E rere atu nei te kreimanga nui te awa o ngā rangatira, e tūmai rā te pā o kororipo. Titiro whakararo ki o rongo ki tākau awa. Te wāhi mata ara tia ai e puhi. Te wakatūpuna mā tātua e moi mai rā, e moi mai rā. Piti whakateuru ki te ngā here nui o Puketi. Pohutu noa ki te moana o Māpere, a whio te rangi ki runga whakataha maunga, ke raro ko te awa o Waitangi. I rere ki pōkākā tō tika te whatu manawa ki i pipiri ki Waitangi. Ko whiti ora, hiru hārama hou, tākau ki mā tātua, tākau, tauwharanga marae, ngā tirehia te hapu, ngā puhi nui tonu te iwi, tēnā koutou, a tēnā rā tātou katoa. Tēnā koe te tuahime, tēnā koe. Ari anō kia ia koe taku tuara, tēnā koe. Greetings everyone this morning. I'm the chair of the Taputai Incorporation, and we have some of our trustees amongst our whānau here. It's difficult when you've already heard some of the kōrero when you're just doing an opening, which was supposed to just stay at one place. And I will remain at that place, of course, as I have our two representatives here talking on our behalf. All I would say is that wa mātane whenua e hira, e korora au ki roto I tōku rea te tōtai. Ko mātane whenua, mei ka tinihia mo te aharaini, ka tinihia te āhuatanga o tō mātane ao. Ka tirohia tātou, me pēhia tātou I noho ki roto I tēnā ao. Ka tinihia kia pēra. I represent, of course, and our trust represents many of our shareholders that our incorporation is responsible for. And that responsibility, of course, is firstly and foremost, kia kore te whenua e riro. Kia kore te whenua e riro, which translated is that the retention of our land is paramount. And when we have changes that maybe threaten that, we come together and ensure that those changes don't affect that which is true to our calling, of course. So our speakers, our executive manager, Marielle, and our planner, of course, will delve into the details of why there is an imminent threat to our existence and to the retention of our land in many ways. But we have these threats imposed on us many times, not only in our fields of our incorporation, but certainly in other areas. And we need to ensure that the benefits of change will then come down to the benefits of our people, to the benefits of their children and their mokopuna, and for the future. I think that's enough, Marielle. I think that's enough. Kia kite ai koutou he hakoa he tini pai, he tini raru, he tini tanga. Regardless if it's a good change or a bad change, it's a change. And we've been often exposed to changes throughout our history that have started out as being good changes, possibly, and some of them have been. But our history tells us that we have to be very cautious. And that cautious approach have seen us and put us in good stead to where we stand now to be one of the most successful incorporations. Papa, my sister at the back here, of course, Runa, within our region. And that success has been on the back of our tikanga and trust in what we've been taught and what's been handed down to us by our tupuna, of course. At the forefront of all of our decisions are made with them in mind and to set us up and for us to take us with us. I'm heartened by the fact that you had the opportunity to visit the place that we're talking about today. And so you can imagine why this is something that we hold true to our hearts, our whenua, the little of whenua that we have left. Mario. I have to acknowledge this boy before he stands up. His father. His father would be doing what I've been doing here if he was still alive. You know, and so we do this not only for the people that are here, but for many that aren't here. So, reira I runga I tēnā me wai hona te kone, e tuita tina koe. Me hoki o kumahara I ngā rautau ki muri. Roa noa to tau nei tūtakitanga. I taua wā, kahana taua, te rapu e huarai, hei orana no toku hapu, a Ngāti Engia. Nō reira I runga I tēnā, e mihi ana ki te tepu o te kaunihena. Felicity, I won't be as brave as Walker was to mention anything about his desires and hopes and aspirations for you, Felicity. So, mihi kawana kia koutou, ki ngā koutou. We will sing a song when our last speaker is finished. Reira hui ana, tēnā koutou mo tēnei whakaro, I whakawātea mai tēnei kōrero o mātou. Tēnā koutou, kia ora tātou katoa. Kia ora Steve, tēnā koe.
Just before you move on, I guess I should have acknowledged earlier that we did site visit yesterday. I was sort of assisted by Mario himself and Mr. Sterling. Commissioner Foy and I were there. Hilda has no property reason to do that.
She knows the water.
I think you've paddled around there about the commission and Walker. I don't think you've been to the site, but we might be able to
Kia ora.
visit it.
Kia ora.
We had a beautiful day like today, so perfectly still. And I think we saw the gem of that coastal environment for what it is. And so we've got an appreciation of its layout, but also its charm and its reasons why we value it so much. So thank you for letting us do that. So we'll just put that on the record.
Hello everyone. Yeah, I'm Stephen Saxon, and I'm just going to, I guess, talk through a summary of my earlier sort of evidence achieved from June 2025 and my supplementary evidence from October back to council around certain aspects. So I've had this wave of starting and stopping, and so I'm just going to try and quickly summarise where I think we're at.
So just to confirm, this is the evidence that you presented at hearing 10, the multi-purpose zone, correct?
No, it's not.
Oh, no, that was the previous evidence that you're referring to?
Yes.
Yeah. It is.
Yeah. Yeah. Oh, no, sorry. How I understand it is we presented at hearing 10.
Yes, that's what
and we got evidence ready, which was then paused and then deferred
Yes.
till now.
Correct.
Yeah, so that's.
When you said I'll go back to my early.
No. And so everyone that's been there, and you guys have seen the context we're talking about is quite important, because as you'll know, and the site's currently in numerous zones. The coastal residential zone at the forefront there, with quite smaller sections and urban-sized allotments. The coastal living area, which we'll get to shortly, which is around the development area, which is proposing a larger landholding, which has the beef and farming activities. So you've got this, I guess, a mixture of activities on a single site, which now moving forward to this proposed district plan seeks to sort of wrap the landholding all into one single zone, the multi-purpose zone. Rural end, so I continue to say that that's just a poor fit for what's on the ground. The aspirations of the people for the land, the only land they've got, no one's making any more, and what's actually there on the ground. So that's the first sort of core argument, I think, is that we're still trying to push this land into a single zone. And the second argument, or second core thing in disagreement, is around, I guess, how we provide for housing or activities on such a large. So, and I'll go into some minor leads and minor details. I won't sit on that for too long, but I think it's important to the lead in detail I'll go into sort of provides the context around what type of issues could occur if the site's called or described as a zone as multi-purpose zone rural. And so I've got a brief handout which just talks about the implications of the setback rule. And so 42A planner and myself have gone back and forth on that, and there's an exemption or there's not an exemption, but my sort of understanding of the rule is that because there's a road that cuts through the site, is that you're not actually exempt, and so you've got a 10-metre setback rule which will apply to the properties, which is on the second page of that handout. And so any sort of redevelopment or any type of new building would be impacted straight away. And so I've just pulled out that one example to show the impact for that coastal residential area if it's zone multi-purpose rural, and Mr. Ohio will go into more detail around the impact of that from other aspects that I sort of can't get into. From a planning perspective, that wipes out quite a bit of land, especially if you're looking at the site and not looking at the ocean, which everyone does, but actually if you look back, a lot of those properties are on the only flat area because there's a massive hill and slope behind you. And so I just wanted to point out the sort of practical implications of if we keep going down this road of saying that front area is not what it is, which is small sites, urban. And despite the terminology used or the definitions being imposed that it's got to be serviced and have council infrastructure, I think my planning opinion is that when I go down there and the sites that I see, it's far more urban than it is rural. And so just moving to the I guess the assistance given by the 42A report right around the coastal living area and providing, trying to match up some form of residential activity or public highway activity for that area. That is, I do support that. And yeah, I note there that even the transport planner sort of saying he thinks that even the coastal living area is more akin to an urban typology. So he's he's sort of on the same boat and wanting us to wanting the submitted to put in footpaths and all types of urban amenity without the zoning. Yeah, and so just thinking that we've got two areas which have an urban character, but none that have a zoning that immediately fits. And so, whilst I agree with the use of the Taputahi development area, I do have a concern with the narrowing it just to Pakakainga only, and I note that in my evidence that in terms of an effect or a final outcome, I don't really see the difference between the development of Pakakainga or residential activity. The houses will be developed. And Mr. Hall will sort of provide further evidence around how then providing housing then goes on to support the community. And so to make a comparison for general land and just in a development perspective, I don't see the PUP requiring, let's say, developers to qualify their housing choice in the same way, forcing or reaching a single pathway for housing. And I think it's inequitable to require that of public zoning. Because just thinking of it from a development and planning perspective, there are a lot of things to consider, and it could be a mix of, let's say, leasehold development land. It could be all leasehold, or it could be a mix of leasehold and Pakakainga, or it could be all Pakakainga. But yeah, there's a lot of at this part of the development timeline. It's quite hard to provide the certainty when you've got to consider costs and a range of other factors. And I guess this development area is trying to force upon Taputahi the final mix, where the plan doesn't do that for, from what I understand, we don't have inclusionary zoning or any other type of approach. So I think we all understand the landholder is unique and it's got various zones and there's various activities, and both sides trying to perhaps force it into certain zones or a standard zone plus a development area. Maybe I'm missing the point, or maybe both parties are missing the point. That maybe it isn't simply to swap one zone for the other. Perhaps we need to widen the lens and look at other solutions. So. Now that I sort of reconsider the whole thing and the multitude of zones, and having gone through the experience of considering other sort of planning tools, more and more I look at this, a precedent seems to be the obvious solution that could outline the controls for the coastal residential area, the coastal living area, and then the broader balance of the farm. So just a suggestion on that one. So that's one of my parting gifts. If that's not acceptable, if that can't be done, then just maintain that we support the ingraining of the development area and allowing the 20 units, but we just don't think that pigeonholing the submitter into Pakakainga only is equitable, and if the precinct also isn't considered appropriate, then consider the coastal residential zones still to be multi-purpose urban, as the development area doesn't resolve that zoning conflict with those allotments. Happy to answer any questions.
Yeah, so you're saying now a precinct would be appropriate?
Yeah, I think it might have been less helpful to the sort of 40-day report writer, providing evidence as we go, and having time to maybe zoom out and get out of some of those details. It appears an obvious choice. So yeah, that's just on the table if it's acceptable and all possible.
So this pathway was established by Minute 14 in December last year. And here we are on the last day of the last hearing. And we're hearing the first time, and you think there should be a precinct in the afternoon?
No.
No, so, and we're at the starting point of what facilitated the process in December last year. It sort of puts us in a bit of a sticky situation. So we're here to try and come up with a solution. We're in a sort of slightly odd position where we've got Māori-owned land. It doesn't want to be zoned Maori purpose zone. Usually it's, and that's what we're trying to understand is why won't this zone? Why won't this zone work? And the next question that comes out of that is what zone will work? I know there's the multi-purpose urban zone, but that's got quite a definition that says it's going to be reticulated, and it's not reticulated. So that's the way the plan is formulated in that regard. We don't have the operative zone of the coastal residential zone, so we can't shoehorn an operative plan zone in here. If you enter a general residential zone, you're struck by the same infrastructure connection limitations, which possibly leads to something like a settlement zone. But we're sort of, we're a little bit unsure as to where we want us to go, setting aside that we're here at a precinct for the first time. So, yeah, I think we probably need a little bit more guidance from you as to what we can actually deliver in the time that we have available to us. Sure. I mean, I understand Ms. Burkhart's taken the initiative of coming up with a development area to establish the Papakainga housing option. It seemed to me that was quite a pragmatic response to your earlier evidence. And Ms. Burkhart took it upon herself to do that work on your behalf. But we still have the land out front, and I suspect that's where you want to talk about next. So is that the commercially sensitive information you want to deliver? Maybe, and if so, maybe we need to hear that before we sort of discuss what to do next. Because what I think this panel would really like to understand is why can't that multi-purpose rural zone not work? Why won't it work? And what we can do with what we have as a toolbox to do that. So again, I'm back in your hands.
So it's a question to me, or what?
Well, I think it's really, yeah, I think we really need to hear this other evidence. Because I think that, because what we're trying to understand is why you've got all those leasehold properties in that coastal frontage there. That the evidence says a multi-purpose rural zone would work. So we need to understand why. And then I think that might then give us a little bit more clarity as to how we can further resolve those issues.
In that case, Mr. Chair, if the commissioners if the panel is happy to hold their questions for Mr. Sampson, and for me to do my evidence, and then we can come back with.
Yeah, I think we need to understand that context better. And I think once we understand that, we'll understand the issue more, and then I think maybe we can explore that further. Is everybody happy with that? Yeah, so are we at that point now?
I would like to talk about who we are first, if that's okay. Commissioners, members of FNDC, our kaumātua kuia, members behind us, tēnā tātou katoa. My name is Mari Alpuhai. I'm the Executive Manager of Taputahi. I know we've already clarified that. And like many of the board members behind me and whānau here as well, I'm a trustee of a trust that is a shareholder, and I'm also a beneficiary that I benefit from the activity of the incorporation. So we have 500 shareholders, but actually the benefits go to thousands. should just sort of make that point there. We've been involved with the hearings over the last 2 years, spending thousands of dollars in this process. Not just because of what we want to be doing in the future with this new development, but also to protect, as you heard from our chairman, what we've achieved in the past. That has taken a lot of time and energy. And I understand the commissioners have read my lay evidence, but I just wanted to go through and highlight sections of it, and also for some of our people who have come to talk to us today. They are shareholders as well. So yes. So since its inception in 1965, our people have strived to develop the incorporation to protect our land from being taken by the rating scheme. That was the primary purpose that our people agreed to amalgamate 3 parcels of land to stop the rating scheme taking our whenua. Kei kaua te whenua e riro wai. And so since that time, in 2008, we had a new rent review, and we've managed since then to be able to expand that brief and start providing benefits back to our people. Up until, pretty much up until that date, our people never, from 1965, never really received any other benefits other than preserving the land, holding the land and making sure the land was never lost. We have a kuia, Mane Rewa, her grandfather, who a lot of us come from. He was born prior to the signing of the Tiriti, and she's watched that whole journey of our incorporation. And she said to me, when they did get the odd occasion to get maybe something, they all agreed that it should go back into the business. So that's how long it took us to get to this point in 2008 from 1965. And I think I just really wanted to make that point about all the effort that's gone in using the planning laws. Some of the highlights, some of the highlights we've managed to achieve since 2008 is to double the size of our land holdings. We now have 3 land blocks. Taputai incorporation of the parent block there was never economic for farming, or at some point it became uneconomic because being 120 hectares with as a beef unit, just didn't return, just didn't give us the return that we needed. So we now have economic scale. We still only have 1 labour unit, the farm manager running all those blocks, and that's the right economic scale now for our farming to cover all its expenses and manage the land and return a small profit annually. So yeah, as kaitiaki, we've been looking for ways to also use the land, but not impact on it, for future generations. We're just here for a time, and we've got to look after it as it was handed down to us. And so we've been looking for innovative ways to use the land. And one of the ways we've done that is a decade ago, we joined First Light over a decade ago, which is a Wagyu crossbreeding business with New Zealand animals, beef animals. And that's about specialty farming, adding value, doing more with less, rather than intensification on our coast, where the impacts are not just to the whenua, they're to our moana and our watercourses as well, which are where our people gather kai. So we haven't quite got the results there with the IMF, intermuscular fat, or the marbling in the Wagyu. And so for the 5 or 6 years ago, we started our own genetics improvement program around the marbling. And so at our Taputai block now, we have a breeding program there where we're 2 years away from seeing the results of that program, and that'll be the test whether we carry on or not. But that's one of the innovations that we've done. On Monday, we've got some trees that we're salvaging from a top energy corridor that was banged down on one of our farms that they've cleared under the lines and knocked over a whole lot of totara and stuff to create that 4-metre corridor. just as well it's not 32 metres, those that were here in 11. We're salvaging that wood to develop a relationship with a company down in Christchurch called Innate Furniture, who make high-end furniture. They've been test piloted, I think we've been tested for a while now with tōtara. We're looking to try and develop that relationship, build that relationship, and start this whole new industry in Taitokerau around tōtara, where it grows prolifically. So the furniture made like a coffee table will have a GPS coordinate on it. People can scan that coordinate and see where that tree came from on our farm, and then they can know that that was sustainably harvested. So this is just one of the initiatives, another initiative that we've been doing. Yeah, and then to that end, we're in the process of finalising our sustainable harvest plans for tōtara, so that we can sustainably harvest it. We've discovered we were part of the TIP project, which is under the Taitokerau Māori Forestry, where we actually discovered by naturally thinning the tōtara stands, it actually supports them to grow better and stronger. So, and we harvested the wood that was thinned because it gives more canopy, more space for that tree to grow rather than one tree killing the other. And so we harvested that wood, and that also went to Innate. So we're looking to now really develop that relationship. And those are just some of the endeavours that we are sort of we're doing now. That's only been made possible because of our beachfront development. The revenue we receive from that has given us the means to hold on to the land and then start innovating, looking for ways to create new industry, to work with our natural resources, make the land, all the land that we have, get some sort of return off it without compromising it. And with our beachfront leases, I just wanted to talk about our, it wasn't in my evidence, but I just wanted to talk about our relationship with our lessees as well. It's not primarily transactional, you know. Some of them are, we've got shareholder down there that lives down there. We've got whānau that live down there. A number of people there, Hilda will know very well, because they've been part of the Ngāti Rihia Wakaama group, and at various times they've taken on roles as the chairman or the secretary to help carry that kaupapa. So the relationship, some of them are married in. So the relationship's not just, you know, transactional, and they live there. There's a majority of them that live there. They're not just holiday batches. So I think that it's just important to mention that. The proposed subdivision on the parcel of land zone coastal, well, as we understand, as I understand, I'm not a planner, just a layman, that is zone coastal living has been a focus of our people for a long time. So for several decades, boards, some of our big members here, we've talked about this development. And it's just been the challenge to access finance. And I heard the comments around whenua Māori versus general title. Those provisions should be made for Māori purposes on general title, because otherwise then if it's on Māori title, there goes your security. You've got no access to finance. That's been the problem. That's what's taken us so long. Māori initiatives on general title enable, or will enable, them to leverage finance and then develop public. Otherwise, it's going to be very humble what gets developed there. So that I'd encourage council to look at provisions for Māori purposes on general titles. I know it's a, sorry, a digression there. But yeah, this subdivision has been disrupted by a couple of major factors. One was COVID. So we had COVID that we started this way back in 2018, and the other one was our bank, who we always had a long relationship, good relationship with, decided to adopt some of their Australasian policies, which included no new finance to subdivision or farming, agriculture. That was the BNZ some years ago. And so our board pulled them up and spent the day with them, showing them around our farms, and they promised to override their policies, pending the business case. And so that's actually what started our journey then to recommence this project, because there's no use going there if we couldn't access finance. But yeah, had we not had those two disruptions, it's highly likely we wouldn't even be here. You know, it would all be done and dusted, and it would be what it is. And then, yeah, we believe that we're a model. We believe we provide a development model for coastal marginal lands, coastal drive. Like, the best use of the land is, you can see what we've been doing, and the benefits for that, you know, are substantial to everybody. Speaking of the benefits, we make annually significant grants to both our marae, Whitiora and Hiruharamaho. Whitiora is one of the bigger maraes in Taipōkero, and so it's often used for hearings or big conferences, because it's got the ability to take big capacity. Without the incorporation support, it would be a lot more challenging for that, and probably we would only have one marae, you know, so that's some of the benefits. We also have tertiary grants, so we give tertiary scholarships, and we have done for quite some time, and a lot of our children go to university, and that's supported by the incorporation. Sponsorship grants, we also have a quick fire application where our people can just have a quick apply, and they get a quick grant to take their children for representative honours. And then we also have dividends. So we pay dividends annually to our people from the surplus. We have a distribution policy on our surplus, which is a third. So 1/3 goes back to reinvestment, and that's looking after the taonga and all the mahi done by previous groups that were handed down to us. The next third is about new investment. That's for our mauri whakatupu that are coming. We need to get bigger, so we're investing, making new investments to prepare to make provision for them in the future. And then the final third of our surplus goes directly back as benefits, and it's actually our shareholders who direct their board on how they want to distribute that. And that's the grants I just shared with you. So that just gives you an overview of the impact that our incorporation has, and so in the last 15 years or so, that the amount that's amounted to 2.7 million. It's gone back in shareholder benefits, and you can work out that a third's gone back into reinvestment and a third's gone back into new investment. That's how we bought the new land block. So that's the model. It's very simple. We're very lean. We only have 1.8 FTEs running the entire thing, other than the board, who often are doing more than just governance, far more than just governance. They also participate in sub-portfolios and stuff like that, and do duties. So yeah, coming down now, and you heard me talk earlier about the rates. The quotable value would assess our little farm, that's 120 hectares, as at 11.2 million. So if you work that out per hectare, it is a lot. You know, that's a lot of money. You have to try and, if you were to buy that, you would never be able to pay that. And we're rated off that. So we hear about Māori purposes, but whenua Māori in Taipōkero is rated off general land title. That's what determines the rates. And so even though the value of that land cannot be realised, if I've got a $50 million property and I'm paying rates proportional to that, well, that's fine, because when I sell that property, I get my 50 million. But for Māori, we don't. It's a tonga. But we're rated off that. Furthermore, we can't even use that value to leverage because no one's going to borrow against it, even though it's 50 million. No one's going to borrow it. Those are some of the constraints we have, and yet we still pay rates, and we're still being rated. We're lucky at Taputai because we get this old concession for farming, because that's taking in those coastal properties aspects and trying to deduct them. So it goes from 11 million down to about 4.5 million under the proposed postponed rates. We still have a liability of $500,000. So if we ever change what we're doing, that's the bill we have to pay to get out of farming. So we're kind of locked into farming, hence why we've got economic scale. But the rates that we're paying are still high and would be somewhere from 50 to 65% of our gross income as a beef unit in rates. That's extraordinary. I mean, work it out. That's the constraint that we've been negotiating against. The postpone or the farming concession drops it down, but even then, 120 hectare farm, effective farm, with some bush areas, that's still way too high. If you went inland and found a farm, I think you'd find a much bigger farm for $4 million inland. So we're still being rated highly under that scheme. That is an old scheme, that post-sprain rate. You can't get that anymore. So other landowners, they just have to endure it. But as a result of that, so we've paid, over the last decade, we've paid FNDC our little farm block, plus our lessees, they all pay individual rates. We've paid over $2 million in the last decade towards FNDC. So it works. Everybody's winning in that model. We're contributing back to our local council, all of those things, but that's just sort of, this will impact on. This proposed multi-purposes would have an impact on those rates for sure. I can assure you of that. So yeah. So yeah, some of my evidence has talked about some of the planning stuff and some of those urban rules and stuff like that. That's been made. I've recently learned the interpretations of the council as to how they interpret urban and stuff like that. So I find that quite challenging, because it kind of feels like, and like Mr. Sampson said, Taputai is unique. It's the only beachfront development like that in Taitokera, in the Far North District, sorry. If you go to the south, you've got Pukahaka Trust or Pātawa South. It's the other development where you've got that beachfront development where they've got tenants there that pay rentals and stuff. So there is something similar at Waitangi, but I know that's very farmer-centric, that they're housing there. Well, here in Waitangi, should I say. But yeah, I do acknowledge the efforts made, Teresa, thank you, with making provision for us in the plan. However, I do have a question around the interpretation of papakainga, like whose place is it to define what papakainga is? Should that... Oh, sorry.
You want to ask me?
Yeah, sorry, no.
There's no direct cross-examination.
Sorry, and it was just, that did stick out to me, because when we talk about papakainga development and this development that we're doing, somehow it's got coined with that, papakainga development, but we haven't determined what that composition is, whether some of it will be for our whānau, and some of it will be for following the same model as that we have down the bottom of the hill, because that works.
So I think what you're setting up is there a definition of papakainga and how narrow is it? I think what you're saying is, how wide can that definition be? Are you able to assist us with that issue?
Yeah, inclusive defining.
There is a definition of papakainga in PDP.
Yes.
Do you want me to read it?
Yes, well, it might be good for us all to hear it.
Yep. It means an activity undertaken to support traditional Māori cultural living residing in the Far North District on A, Māori land, B, treaty settlement land, C, land which is the subject of proceedings before the Māori Land Court to convert the land to Māori land, or general land owned by Māori where it can be demonstrated that there is an ancestral link identified. Whakakainga may include, but is not limited to, residential, social, cultural, economic, conservation and recreation activities. Marae, wāhi tapu.
So that's, and I suspect any national environmental standard would have its definition too. Are we working on an exposure draft definition there as well?
I believe so.
Yes. So that's the definition that the plan has. So perhaps my question back to you is that wide enough for your purposes?
Well, it should be left to us to determine, because in the reason I say that, and I sort of alluded to it earlier, is that we've done a lot of thinking around housing our people, around Whakakainga development. And we've had surveys with our people and delved into this quite a bit. And when we come, what comes back at us is protecting the equity. If we have a bit of Māori land and whānau expected to go and build a subdivision or Whakakainga housing, well, the minute they put their houses there, the value of those houses topples, because you won't get a mortgage off those. You know, the cost of building a house on Māori is higher than what you would be able to secure it for. And so some of that thinking, so where we've landed is that actually we need to protect their equity. And in fact, if we do that, they're inclined to build bigger houses, nicer homes for their families. And so when we talk about a subdivision for our people, we look at the model that we had down at the beachfront, and then we look at our whānau. We don't see really any difference to the way we might approach those two things, just different markets. So one will be the open market, one will be the general market, the other one will be the whānau market. And so then whānau get to determine the land values. But then they get to preserve their equity. They can even raise security. We've been working with the banks on what makes a good lease. That's some of the thinking we've done around it. Our concern is that the rules around, or the interpretations of Whakakainga are going to have disregard for that, because what their expectation is what they imagine as a whole lot of houses clustered together. I mean, you're living amongst each other. So that was, thank you for allowing me this time to speak to that.
Would you like to take some questions on that aspect now? Keep going.
I've got that. Yeah. Then I could also, it could be that moment where we want to share with you.
Okay, well, let's keep going then.
Yeah. So
this is the moment you'd like commercial setting to this.
The moment set.
Now pause the recording.
Recording.